Welcome back to the channel. What is going on with the goings on with Little Woody? So today they had to bring Little Woody back in due to the ex parte meeting that they had illegally that got Judge Glanville recused and basically removed from the trial. So they had to explain to Little Woody about his immunity as well as him pleading the fifth. In reference to him pleading the fifth, he was told by Judge Glanville that he would have to sit in jail until this trial ended, as well as the other 12 defendants' trial ended, which is not true. So they had to explain to him they only can hold him until this trial ends. And the immunity that was given to him does stand, but this judge is doing the same thing Judge Glanville did. She's telling him it's giving him immunity, but it is not giving him immunity when it comes to the feds as well as murder. So let's get straight into it. Don't forget to hit the like button, comment below, and subscribe. Thank you.
Hi, good morning, Mr. Copeland. I'm Judge Whitaker. I think you've been before me before in unrelated matters. I'm the judge taking over this case now. So go ahead and have a seat. What I want to ask you right now, I know that you have been given immunity with regard to your testimony. And there had been, at some point, you didn't want to testify. At some point, you did want to testify. The first question I have for you...
I never wanted to testify.
Okay, the first... Well, right, want to is maybe the wrong term. But my question for you right now is, do you have an attorney at all?
I don't know.
You don't know whether you have an attorney? I would think that would be a no then, if you don't know whether...
I was talking to Melanie, but...
Melnick?
Yes.
Okay, didn't he ask to be relieved as your attorney, and did you sign something saying that's okay, you can get out of this?
I don't.
You don't remember? Okay. Does anybody know whether that actually occurred?
I don't believe it occurred.
Okay.
I believe that Miss Bumpus,
I know she was stand-in.
she was standing, and I believe something was said on the record to the effect that Miss Bumpus was relieved. But
yeah, I know she was.
There was nothing about Mr. Melnick to my knowledge.
Okay, maybe
there was. Miss Bumpus actually said yesterday, I believe, during her testimony, that Mr. Melnick had directed her to tell Mr. Copeland that he could either exercise his,
well, choose not to testify.
Right. Or if he chose to testify, according to Miss Bumpus.
Yeah, I remember she said, there's this paper I'm supposed to get him to sign. I'm trying to figure out whether it got signed.
So I never got Mr. Melanie off my case.
Okay, so he's still your attorney then?
I guess.
Okay, all right. Well, then that's the answer we've got for that. All right, so I'm going to try to get a hold of Mr. Melnick and see if he can be here with us this afternoon, because some of what I suspect you recall when you were brought into Judge Glanville's chambers with Ms. Bumpus and a couple of the people from the state, there was a discussion that Ms. Bumpus and Ms. Hilton and Judge Glanville had with you. You asked some questions. They gave you some information. Some of that information was not actually factually correct. And I want to make sure that you have the opportunity understanding what it is that the immunity order means, understanding what the potential consequences are if you do testify or if you don't. We're basically going to kind of start over and
So
do
if I
that
don't
over.
testify, so if I don't testify, how long you gonna hold me in jail?
So, I mean, that's still an issue that you can be held in jail through the end of this trial. But I'd rather have Mr. Melnick here to advise you about the potential drawbacks and benefits of what, if there are any, of any of your.
To the end of this trial?
Yes.
Not the other people.
Not as far as I believe, but the state, what, did you want to do some further research on that?
Yes, just to advise the court of.
Okay, so I just wanted to know, first off, do you have an attorney? Because if you do have an attorney, your attorney may have some information, advice, research for me about that. So I want to make sure that I tell you the correct thing about that, okay? So we're going to take a lunch break in a little while, and why don't we plan to have you back here on standby at least. I don't know who was in communication, but we need to reach out to Mr. Melnick, see what his availability is. So just be on standby in case I need you here, like at 2 or 3 this afternoon.
2 or 3?
Yeah, because we're about to take a lunch break for 2 months longer. So you're okay to leave for the next couple of hours, but stay where whomever reached out from the state can reach you to let you know whether you need to be back here this afternoon. All right, hello again, Mr. Copeland. Your attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen and he can see you. If there's any time you want to talk to him privately, let me know that. And I know y'all have had an opportunity since you and I spoke this morning from the bench in the stand to talk about the fact that the state is not interested in you pleading the fifth, and in order to avoid you pleading the fifth, they have secured an order that says you now can be essentially compelled to testify, because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for, if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections have been February or March of next year. I don't know yet, but I guess that's not outside the realm of possibility. But it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said at the beginning.
Didn't understand anything. All right, so.
No, I'm saying, like, I heard you, but I don't know what you're talking about.
Okay, so tell me what it is that you'd like more information about.
You said something about what they said about immunity?
Yeah.
What you mean?
Okay. Does anybody, I think I've got the order. Mr. Melnick, have you reviewed the immunity order with him?
Oh, it's the same from last time?
Hang on a second. Yeah, the same one as last time. Yeah. That's one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed.
All right.
So what has changed is, it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been told something different earlier, and I don't think that is
So I ain't gotta wait till every defendant that's not here.
correct. But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which might be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses, so it could take a while.
Can I speak?
You can,
I have
you
told
have
the
a-
state.
Huh?
I have told the state I have lied and lied
I
and
know,
lied and
I
lied.
know, and
So how are they gonna be able to question me?
I mean, that'll be their problem. That's their case to make or not make. I mean, that's not for you or me to worry about. So,
They said they're gonna be able to charge me if I lie. Like when it's up to them to choose when I'm
not private. You said you lied in every, no, I don't know what you said, but let's even say you've said you lied in every statement you ever gave to the police. If you want to stand and say that, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. They might be able to charge you with is, I don't know, I mean, give me an example of something that you know he didn't do, and, well, maybe not, never mind, don't do
Can I give
that.
you an example for what they told me?
Yeah, yes, and then I'll see whether that's what I think or not, yes.
So she said that the only reason she won't lock me up, I just want to know if it's still a fact.
Okay.
She said if I do two things, if I plead the fifth and I say that I killed Donovan Thomas.
Okay.
She said if I don't say them two, she will not lock me up.
All right, what was the first? Okay, right. And you can no longer, so taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you could then use against me. That's what taking the fifth at this point would get you in trouble. Being held in contempt is what we
So what if they
formally call it.
they facts together? Like they saying something that they don't know what they're talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime. Okay? So, what I want to know from you is when we have the jury back on Monday and you're still under subpoena, so you're still obligated to come, and I'm asking you now, when they're like, all right, we're calling Kennedy, I'll tell you whatever I'm going to tell you. Or are you going to say, nope, I don't care if you throw me in jail, I'm not saying a word. I am not getting on the stand.
Depending on how I wake up.
Okay, all right.